So one of the first things I want to talk about is the charges in the case. As in this particular case, as I've talked about before, there are 7 defendants, and there are 3 charges. The first charge is conspiracy to impede or interfere with federal officers. The second charge is possession of firearms in a federal facility. And one thing that I want to point out is that the way this particular firearms charge is alleged is that it is based on the possession of a firearm while in commission of another crime. So just the fact that they had firearms alone at the wildlife refuge is not sufficient to meet the government's burden of proof. The government has to prove that they possessed firearms while they were committing another crime at the refuge. And the third charge only applies to one person in this case, and that's defendant Ken Medenbach. He's charged with theft of government assets. He's charged with basically stealing a wildlife refuge pickup and driving it to Safeway and Burns to get groceries. Now, let's think about some of the elements of these charges, and I want to start with the last one, which is that theft of government property. The way it's defined is that the government has to be deprived of the use of that property. So the government has to show that Mr. Medenbach took that property, in other words the truck, the vehicle, with the intention of depriving the federal government of its use and with the intention of not returning it. So the government has to show that even though Mr. Medenbach claims that the truck was there, the keys were in the ignition, he used the truck, he returned it to the wildlife refuge, the government has to show that he intended to steal the truck, take it away from the government, deprive the government of its use, and not return the truck. I've talked a little bit about the firearms charge. The firearms, there are a couple different elements of federal firearms charges. In some cases, you can be charged with unlawful possession of a firearm in a federal facility if you possess a firearm in a facility that is clearly and conspicuously marked not to allow firearms. That's the case in federal courthouses, for example, most post offices, a lot of other things. The law actually says that it is unlawful to possess firearms or other dangerous weapons, which includes a pocket knife over 3 inches long, in any federal facility, which is defined as any federal building, including, say, for example, a Forest Service outhouse. But in this case, because there were not signs conspicuously giving notice that possession of firearms was unlawful, what the government is charged is that these defendants possessed firearms while committing another crime, another federal crime on public property, not public property, federal property. And I'm going to come back in the next clip so that I can keep this one fairly short and talk about the conspiracy charge. So in this clip, I want to talk about the conspiracy charge. The government has charged these 7 defendants with entering into a conspiratorial agreement to impede or interfere with federal officers in the commission of their duties. And so the government has the burden of proving that these defendants entered into a conspiratorial agreement to do that. So let's look at some of the evidence that's been presented so far in that regard. It looks to me like, and I've talked about this in some of the other things I've written about this case, and especially when you look at the definition of a conspiracy, really all a conspiracy is an agreement. There can be fully lawful conspiracies to do all kinds of things, from play a prank to have a surprise birthday party. But in order for a conspiracy to be illegal, it has to have an unlawful purpose. Now, I think it's fair to say, based on the evidence that's come in so far, that there was a conspiracy, there was an agreement, there was a meeting of the minds between a number of different people, basically, to engage in a protest rally to support the Hammonds. And there was also an agreement between some people to occupy the Malheur National Wildlife Refuge. Now, whether or not there was a conspiracy to impede federal officers comes down to intent. Conspiracy is all about intent. It's all about the purpose of the conspiracy. It's all about the state of mind of the alleged conspirators. Now, from what I've seen so far, and I think this has kind of been demonstrated in the in the government's evidence too, there were a whole bunch of different people there. I don't think it looks like they were all on the same sheet of music. It looks like Ammon Bundy and Ryan Bundy and probably Lavoy Finicum and Shauna Cox and some other people had some objectives. Then there were a whole bunch of militia people and other people that came there. They had their own agendas. And I'm not sure to what extent those agendas overlapped. And the government has the burden of proving that they did overlap and that it was the intent of these particular defendants to impede federal officers through the use of force, intimidation, or threats. And most of these witnesses have already testified that they're not aware of any actual threats by these defendants or anyone else. They haven't been able to point to any actual threats. And they haven't been able to bring forward so far any evidence of any actual force of any kind that would have been used to impede. So it comes down to a matter of intimidation. Did these defendants intend to impede or, intimidate these federal officers with the purpose of impeding or interfering with their duties? And that brings us to another question that I'll hit in the next clip, which is, what was the primary purpose or intent of these defendants? Was it to impede the federal officers, or was it something else entirely? And we'll talk about that in the next clip. So in terms of his purpose or intent, Ammon Bundy has said that his primary purpose in occupying the wildlife refuge was to stake a claim for adverse possession. I know a lot of people scratch their heads about that and think, what does that mean? What is adverse possession? And without taking the time to spell all of that out in great detail, right now, I encourage you to go to the RANGEFIRE blog, www.rangefire.us, and you can find a number of different articles and other materials there that talk about adverse possession. The real question in terms of this clip is talking about not the elements of adverse possession, because I don't have time to do that. It's a fairly complicated subject, but whether or not there's evidence that even in the government's case, that's what Ammon's intention was. You've got to remember, the defendants haven't yet even begun to present their own evidence and what their intention was. So this is based on the government's own evidence. So what the government has shown is that these defendants came to the refuge and they took possession of it. They occupied it. Those are elements of adverse possession. You have to do that in order to stake a claim for adverse possession. You have to possess the property, you have to occupy it, and you have to try to defend that property in a sense. So it looks like the government is actually presenting plenty of evidence that would support that element of that claim. In addition, the government has presented evidence. One of the things that they did recently when they were examining Linda Beck about her office, the condition that she found it in and everything, they showed photographs of her office, and one of those photographs included a whiteboard, and she claimed that whiteboard was in the condition that it was left by the defendants. And so when they zoomed in on the whiteboard to see what it said on cross-examination, what it said right at the top of the whiteboard was adverse possession, and then it listed some of the elements of adverse possession. The government and a lot of other people have claimed that this adverse possession claim is something that Ammon Bundy came up with after the fact to try to cover his tracks, and that it's some kind of convenient after the fact defense that he's trying to come up with, but the government has already presented evidence that that was part of what he was trying to do while he was occupying the refuge, and it's included in the evidence that the government has presented thus far. So we'll continue these clips, and I'll come back and add some more commentary clips as we go. I have people asking me all the time now as they're tracking this coverage. This is in emails, texts, phone calls, comments on our comment board, asking how a lot of this evidence actually supports the government's case. And I've said it before, I'm not sure how the government thinks a lot of this evidence supports their case. I'm scratching my head about that as well. But one of the things that I think is really interesting, and I've talked about this quite a bit before, especially in the articles that I've written for Newsbud and Boiling Frogs Post, I think judicial transparency is a huge issue in this country. And I think this case is a great example of the issues that we have in this country with judicial transparency, because most people simply don't know what's going on in the judicial system. Most people don't know what's going on in this case. There's very little media coverage of this case. There are some media outlets, including some mainstream media outlets in Oregon that are covering the case, including Oregon Public Broadcasting and the Oregonian and Oregon Live, but very few other mainstream media outlets are doing so. Some have kind of included an article saying the trial is starting. They'll probably have another article at the end saying what the outcome was, but there's virtually no one else that is trying to give people who really want to follow the case and know what's going on any way to do that. I've suggested that there's really no reason why a case like this shouldn't be live streamed to a website where anyone and everyone can go and follow the case, follow the proceedings, see what's going on, see what the witnesses are saying, how they're saying it, observe what the judge is doing, see what the attorneys are doing, what they're saying. Then people don't need to rely on my commentary. They don't need to rely on my opinions and what I'm saying. They don't need to rely on the opinions of other reporters. That's kind of the day and age that we live in, but our judicial system continues to be enshrouded in secrecy and mystery to such an extent that no one can even take a picture, not only in the courtroom itself, but not even in the courthouse. So we have to rely on these artists' renderings of what's going on in the courtroom. And my position is I just don't see any real justification for that at this point in time. I think it would be in everyone's best interest if we could just see what's going on. It's the same argument for transparency in law enforcement. It's the same argument for dash cams and body cams. The same reason we should have cameras in the courtroom recording what's going on and allow the public to see for themselves. Then it could remove a lot of the doubt and discussion about all of this. We'll talk more about that later. The seasons are changing here in central Utah. I'm back at my back gate on the hood of my truck, my outdoor studio. I've been catching quite a bit of flack lately because I haven't been doing as much live coverage and commentary about the Oregon standoff trial as I started out with. In other words, I've been writing more about it, summarizing each day, but I haven't been taking the time to shoot these little video clips, and so I'm catching some flack for that. The reality is, like I said last week, I had to come back home and catch up on some things. We had a nice storm which required me to do some farm and ranch work here on my ranch that has had me occupied for the last week or so. But I am heading back to Portland next week, and so I'll be getting some more live coverage and commentary from Portland next week. Today I'm decked out. It's Red Shirt Friday. That's something that my good friend Trent Luce reminds me of on a regular basis, and since the seasons are changing, I shifted gears from my straw hat to my black felt hat, and I'm even wearing a red wild rag today to emphasize the Red Shirt Friday. Those of you who don't know what that's all about. It's a tradition that was started back during World War II, when people would wear red shirts on Fridays to show support for the troops who are fighting for our freedoms in this country and around the world. And so that's a tradition that Trent Luce continues to this day, and he reminds people like me that that's something that we should continue to do. It's a little chilly here this morning, so I've got on more than just my red shirt. Anyway, quit beating around the bush and get down to the Oregon standoff trial. A lot of stuff happened this week. I can't cover it all in one clip, so we'll have to include that in several different clips. But the prosecution wrapped up its case and rested, and the defense started its case, started putting on witnesses and testimony and evidence to support the defense case. So I'm going to come back and talk about what happened this week in the prosecution's case as it wrapped up its case before it rested and turned the show over to the defense. Be back with another clip to talk about that. So this is a series of video clips that kind of comprise a weekly recap of the Oregon standoff trial. This week, the prosecution, after only about 9 days of presentation of evidence, in other words, there was a full day of opening statements, and then took less than 9 days to present their evidence, presented all the evidence they had in the case and rested. That happened on Tuesday afternoon, and so the defense started to present evidence Wednesday and Thursday. Again, it's just a 4-day work week for the jury in the trial. There is other work that goes on in the court, and Judge Brown hears motions both before the jury comes into the courtroom in the morning and after they're excused in the afternoon, and at other times during the week, possibly including today, she may hear some motions and arguments from the attorneys on other issues other than what the jury's talking about, or what the jury is able to be present to hear. But the government wrapped up its case, and at the end of its case, basically, it put on what it called the firearms presentation, or the gun show, is how some have referred to it. It was the drama that the government was seeking to wrap up its presentation of evidence with at the end of its case. And in that portion of the evidence, they had a number of FBI agents who had been searching for evidence at the wildlife refuge after the conclusion of the occupation, and they brought in all the guns and the ammunition that were found at the refuge at that time. That consisted of 22 what are referred to as long guns, which would be rifles or shotguns, and 12 handguns, and thousands of rounds of ammunition. And it should be noted that much of this ammunition and firearms, there wasn't any direct connection between those and the defendants in this case. In other words, and I've mentioned this in several other different contexts, as far as I can tell, what happened after the Bundys were arrested and Lavoy Finicum was killed as they were en route to John Day to have a meeting there, then word got back to the refuge about what had happened, and there were probably at least 50 people there at the time, other occupiers and things like that, and they didn't know what was going on, and so a lot of them basically just packed up and took off as quickly as possible. They were like rats fleeing a sinking ship, and a lot of them were probably concerned about what might happen to them or other possible arrests, roadblocks, that sort of thing. And so they just went ahead and left the firearms. They left the place in a little bit of a mess. There's no question about that. They'd been camping out. It wasn't as tidy as it might have otherwise been. I'm sure that they had plans to tidy it up and leave it in better condition. But under the circumstances, they just packed up and left some firearms behind with them. And those are the firearms that the federal government brought in and presented as evidence to the jury in this case to demonstrate what it thought would help support its case. And I'll come back and talk about that more in the next clip. So in terms of evidence that would support the government's case, obviously there are several different charges. There is the primary charge of conspiring to impede or interfere with federal officers. There are firearms possession charges against some of the defendants, and that's part of what I want to talk about in this clip. And then there's also a charge of basically theft of government property against just a couple of the defendants. But if we focus on a couple of things, first of all, the conspiracy charge, what the government is alleging is that these defendants conspired to impede or interfere with federal officers using either threats, force, or intimidation. And of course, during the course of the evidence that they did present, they weren't able to present any evidence that there were any actual threats against federal employees or officers or anyone for that matter. There were no threats. That was the evidence that came in from all the witnesses. I hear things out there on social media all the time about all the threats and that they threaten to kill people and they threaten to kill women and children, all of that. But during this trial, when the government was given an opportunity to present its case, there was no evidence presented of any actual threats to anyone. So then we shift to the next component, which is force. Was there any actual force? Did they come in and take the refuge by force? Well, under the circumstances, the refuge was vacant. Only some of the buildings were locked. Basically, the evidence that was presented was that there was no need for any force to occupy the refuge. So there was no evidence presented of any threats. There was no evidence presented of any actual force of any kind. So that leaves us with the third category of intimidation. And so certainly that is one of the points that the government is trying to make with all the firearms, along with statements that these firearms intimidated people. And there's no question that that argument can be made. As I've talked about in other video clips and in some of the written commentary that I've done, it appears that the government officers in question who were making the decisions were intimidated long before any firearms were really an issue. They made the decisions to close the refuge and the BLM office before they even knew that there was going to be any kind of an occupation. They made those decisions based on the fact that there was going to be some kind of protest rally in Burns in support of the Hammonds. And so we've got this question about the firearms and what role they played in some purported intimidation that played a role in this alleged conspiracy. There's more detail about the firearms that I'll come back and talk about in the next clip. So of the various defendants in the case, some openly displayed and bore firearms, and that was portrayed in the media at the time. It's their position that they were doing that mostly as a symbolic gesture. They were exercising both their right to freedom of speech, freedom of expression, and their Second Amendment right to have and bear arms. Their position is that they weren't using those arms as a means of force, threat, or intimidation of anybody. That's just part of their freedom of expression under the constitutional rights. But there were some people among those defendants who were never seen bearing arms of any kind. And one of those is Shauna Cox. And she was still charged with possession of firearms. And supposedly there was one witness who claimed to have seen Shauna Cox with a firearm at some point during the occupation. And so the government's case against Shauna Cox was based apparently on that witness's testimony. Well, as the government presented its case and ended up resting, the government never ended up calling the witness that supposedly had seen Shauna Cox bearing or possessing a firearm. So the government presented no evidence that Shauna Cox had possessed a firearm at the refuge. So at the end of the day yesterday, Shauna Cox filed and made a motion to dismiss count 2, which was the firearms charge against her. A number of other motions were made and argued at the same time, and the judge denied most of those motions, but took Shauna Cox's motion to dismiss the firearms charge under advisement and said that she was going to go back and look at what, if any, other evidence might have presented that would support that charge, and then make a decision based on that. But there's a good chance that that charge will be dismissed against Shauna Cox. Something else I found very interesting as this whole discussion came up, because someone else that no one had ever seen actually bearing a firearm at the refuge was Ammon Bundy. One of the pieces of evidence that came in was that there was a hunting rifle, a Savage Winchester, I'm trying to remember, it was a 300 Win Mag is what it was, a hunting rifle. They had produced paperwork to show that Ammon Bundy had purchased that rifle in Arizona back in 2012. It was found at the refuge. I think it was either in his truck or one of the other vehicles. I don't know if it was loaded or not, but it was registered in his name, basically, and so that was evidence that was presented that he might have possessed or borne arms at the refuge, despite the fact that he was never seen with a firearm. But one of the things that I found very interesting as I got digging back into this a little bit is that when the Bundys were arrested and when Lavoy Finicum was killed on January 26th, and the FBI was compiling its information to present to the judge in support of the charges, in support of warrants, all of those things, a sworn statement was signed and presented by an FBI agent, Catherine Armstrong, and in that sworn statement, she said that a .40 caliber handgun had been retrieved from Ammon Bundy when he was arrested, that he was in possession at that time of a .40 caliber handgun. That's what her sworn statement said, and what got me onto that, and I started tracking it back, was an article by Conrad Wilson with Oregon Public Broadcasting that made reference to that. So I followed that back and checked on it, and I found it interesting that at trial she was not called, and that evidence was never presented, which really makes you wonder what was really going on. You would think that that would be highly incriminating evidence. You'd think that that would be evidence that was very critical to the government's case, especially against Ammon Bundy, especially when it comes to firearms, his possession of firearms, especially where the evidence against him with respect to firearms was quite marginal anyway. But that evidence was never presented. So that leaves us all wondering what the basis was for that supposed sworn statement making that allegation. I'll come back with some other clips and commentary after this. So my overall assessment of the government's case and the evidence that presented, first of all, I want to point out the fact that there were big discrepancies between the evidence that the government ultimately presented in the case versus what they said they were going to present in their opening statements. In their opening statements, the purpose of an opening statement is basically to give the jury a roadmap of the evidence the parties intend to present in the case. So the government did that. They said what they intended to present as evidence in the case so that the jury could pay attention and watch for it when it came in. But there were big discrepancies in a number of different ways, both with respect to the firearms, with respect to the way the refuge was occupied at the outset and how it was taken when the initial group of people went there. And they also said that they were going to have some of the co-defendants who had entered into plea deals testify in the case. These are people who had entered into plea deals and had pled guilty to this conspiracy charge. And so the government said that they were going to support their case by bringing some of those defendants into the courtroom to basically testify that they had admitted that they had engaged in a conspiracy. But by the time the case was done, the government didn't call any of those witnesses, didn't present that evidence in court. So you've got to ask yourself what's going on here. Either there was problems with all of those witnesses and evidence that the government didn't want to have to deal with. They didn't want to have to deal with the cross-examination and what might come out. Or the government has a lot of confidence in the evidence that's already presented. And I really don't know kind of where they're coming from, because from my perspective, the evidence that has been presented so far, and they've presented their entire case in chief, so the only evidence that they will have an opportunity to present going forward now is rebuttal evidence, evidence to rebut the evidence that the defendants put on in their case. But in the government's case in chief, I consider much of their evidence to be quite marginal. And they have this burden of proving the charges beyond a reasonable doubt. I think that is a concept that a lot of people don't really fully understand and maybe wrap their minds completely around. In a criminal case, the burden of proof, the standard of proof, is beyond a reasonable doubt. So if the government is not able to prove its case beyond a reasonable doubt, as opposed to preponderance of the evidence or something like that, then it has not been able to prove its case with sufficiency to support a conviction. And so that's really the issue that we've got going on here. I think this is a much closer case than a lot of people wanted to think that it would be. A lot of people wanted to think that the government had a very open and shut, black and white case against the defendants, that they could come in with overwhelming evidence and prove their case. And one thing we do need to remember is that the firearms charge against all of the defendants is contingent on the ability to convict of another charge. In other words, the government has to show that any possession of firearms was while committing another crime. So if, for example, there isn't a conviction of the conspiracy charge or offense, then the firearms charge automatically goes away, because that's the way it's been charged. And so I think as you consider all of that, I'll let people draw their own conclusions. I know they're not there watching all the evidence. I haven't been able to be the whole time either, so I'm just providing a lot of this commentary based on my close following of the case, second-hand reports. I'm in the same boat, but I'm trying to analyze all of this the best I can and provide you with some inside understanding, analysis, and commentary based on my experience and perspective. And I'll come back and we'll talk more about the defense case so far in this case in another clip. It's a lot harder to provide good commentary and analysis in short little video clips than it is to write it out, basically, which is what I'm used to doing. So if you go to RANGEFIRE, which is where you must be as you're watching this, you'll see my other written commentary about that. So I'm not going to try to regurgitate all of that and summarize all of it for the whole week, but basically the defense did put on evidence and call witnesses for 2 days. On Wednesday, they called a number of different witnesses. They were basically government witnesses, FBI agents, refuge manager Chad Carges, others who had been called as witnesses for the federal government, and they were recalled by the defense to clarify some things and to shed further light on the defense case. On the final day of evidence this week, which was Thursday, yesterday, the defense only called 2 witnesses. They were the Reverend Franklin Graham and defendant Jeff Banta. And Reverend Graham talked about his role in helping to negotiate an ultimate and final resolution of the occupation. He was there on the ground. He'd been, I'll just say, and you've probably noticed it, that Jeff Banta is the one who recommended that they get Reverend Graham involved, because he said, this is Banta, said that he did not trust the FBI. He thought it would be a good idea to get an independent, neutral third party involved in the negotiations. To the FBI's credit, they reached out to Reverend Graham at Jeff Banta's suggestion. He got very heavily involved, and he was contacting and communicating with the remaining holdouts on a daily basis, and in the end he did end up flying his own plane to Burns. He was taken to the refuge. He communicated with the holdouts there, and he was a very important part of the final wrap-up. Jeff Banta also testified about what happened there while he was there. And let's remember, Jeff Banta had visited the refuge for just one day, hadn't stayed a night. I think he was there on the 9th of January. He had a little bit of time. I've talked about this before. He wanted to see what was going on. He was really interested in what was going on with the Hammonds and how they were being treated. He wanted to go there and meet the Bundys and see if he could size things up. And when he had the opportunity several weeks later, he went back to the refuge to follow up on that. He was hoping at that time to basically have an opportunity to have someone make an introduction to the Hammond family so that he could see if he could actually help them out, work on the ranch or whatever the case may be. But in the amount of time that he was there, starting on the 25th of January, recognizing that Ammon and Ryan Bundy were arrested the next day on the 26th, he only had an opportunity to talk to them for a couple of minutes, basically make an introduction. And so he didn't have a chance to ask all the questions that he would have liked. He thought that he would have that chance later. They were gone then. And so he talks about what happened after that. He talks about the other people who showed up and what was going on there, what his motives and motivations were for going to the refuge, what he wanted to accomplish, and why he stayed after the other arrests and after so many of the people had left. And one of the biggest reasons he stayed, and David Fry stayed, and the Andersons stayed, is because they were afraid of what might happen to them if they left. They knew that Lavoy Finicum had been killed. They were genuinely concerned that they might likewise be killed or that others might be killed, and they didn't know what to do. So they moved out of the headquarters buildings. They set up their own encampment in a tent in the west parking lot. And they were basically left behind, is what it boils down to. And they were just trying to figure out things the best they could. And they were just taking things day by day. And that's what Jeff Banta said. When Judge Brown asked him about his Fifth Amendment right to remain silent and made sure that he knew that he didn't need to testify, he didn't need to say anything, and he said he understood that, but that he had nothing to hide. He said, I've done nothing wrong. I didn't do anything wrong when I went. I didn't do anything wrong while I was there, and I'm not afraid to talk about that. So Jeff Banta spent quite a bit of time testifying about his experiences at the refuge, and we've talked about that in the past.